Hey, good morning, everybody. I'm here with Amy Hsiao, and Amy is an international trademark attorney that specializes especially in Asian trademarks. And so, we're here to talk to Amy today to learn, kind of the relevancy of a bunch of trademark-related issues and information, specifically as it relates to people, small brands that are selling globally, especially Amazon sellers. And I first got to hear Amy talk at Global Sources in Hong Kong, and I was immediately struck by, Amy was the most informed, smartest person I've ever heard speak on international trademarks, and I've actually, believe it or not, heard a lot of people speak on trademark issues. So Amy has deep knowledge, with this kind of complex area of multi-country trademark. And that's hard to find, and so I feel really thankful to have Amy here available today to have a talk about this stuff. So thanks, Amy.
Thank you for having me.
Yeah. Well, do you want to just first kind of introduce yourself a little bit and your firm?
Oh, sure. My name is Amy. I'm a Chinese native speaker. I started out graduated, all the kind of stuff. And I came over to the US for law school about 15 years ago and started out as a corporate finance attorney doing Wall Street deals. And when Wall Street crashed, my firm asked me, don't you speak Chinese? I said, yeah. So that was about the time, like 13, 15 years ago, when China was not a market, but now it's a major market. So gradually we handle from startup all the way to top 10 most famous brands in the whole world, from chasing infringers to being chased by infringers. So pretty much done everything. So that's my practice.
Oh, great. Yeah. And so that's really valuable. Amazon sellers are usually smaller than probably some of the clients that you've had, and yet they're dealing with all the same issues because partially because of the way e-commerce works and what Amazon has enabled, and everyone competing with Amazon, that we got these small companies now that are selling globally, which maybe wasn't the case previously. Well, okay, so one of the main kind of initial driving factors, especially for Amazon sellers in thinking about trademarks, is the Amazon Brand Registry program. Basically, Amazon provides a bunch of extra services and protection for sellers if they're able to prove to Amazon that they own their brand. And that starts with a trademark. And to get into the brand registry, most Amazon sellers are selling in the US. To get in the brand registry program initially, most people think about getting a US trademark first. Now, we're going to talk about international trademarks too, but from the perspective of international trademarks, how do you think about getting kind of a US trademark first as something that is beneficial, not beneficial, maybe even key? When you're dealing with multi-country, what's the kind of ordering issues that you worry about?
That's a great question, because a lot of the clients, if you're not like the top 10 brands, a lot of the clients would come to me like, I already got a US trademark. Shouldn't that be enough? The answer to your question, and I hate giving out a typical lawyer answer, but it really depends in this case. It depends on two primary questions. Is your business primarily focused in the US, Europe, Asia is not a component, or you're going to manufacture in China, Indonesia? You might want to sell in China later down the road. So to answer the question, is that the first step? It's a great first step if your focus is on the Western world. But if you have an Asian components, my suggestion in our line of practice is that it always makes sense to do it simultaneously, parallel steps. We're going to explain, probably we'll get into this, is the system is so different. Sometimes you think you are protected in the US, but in fact, you're just alerting infringers that, hey, I'm coming. I don't really know the Chinese system, but I'm alerting you, come infringe me. So that's why when it depends on what your countries are and how we just set it parallel together.
Oh, wow. That's really interesting. Have you actually, I worried about that as we were doing our international trademarks, that somebody would be paying attention to stuff we were doing in one country and then use that as a trigger to run ahead or race ahead of me and basically steal or impede my trademark in another country. Have you actually, so you just mentioned that as a worry. Have you actually seen that happen?
we see that happen a lot. It's really sad. We see that happen a lot, and especially for like 3 a.m. call from the CEO, that happens a lot. 10 years ago, when we first started, China is such a small country. The infringers mostly stop, like they get your mark and that's it. Sometimes they blackmail you. You pay $2 million. I have an infringer ask me one time, hey, can I get the asking price, the starting price is $100 million US. So to answer your question, before it's more like blackmail and stuff. But 7 years ago, 5 years ago, the infringer turned aggressive. What that means is that they're turning around. They now get your brand. They're turning around, blackmail the factory, threaten the factory, sometimes stop the shipment from coming out from China. And that is kind of like the domino effect, because that affects the whole supply chain to the rest of the world. So yeah, we deal with that quite more than I would like, though. Yeah.
Yeah, and it's so interesting to hear. Certainly I took with my own company a prioritized approach where, I was a certain size and I felt like I could afford a certain amount of trademark protection. And so I did the US first. And it's actually only recently, and after hearing, getting introduced to you, I was actually using your services to then, expand that more broadly, specifically in Asia. And you just mentioned something interesting there, which is, really kind of registering in China as a defensive mechanism. It's not that you're necessarily even selling in China. It's not even necessarily that you're intending to police your trademark proactively in China. It's more that you are laying in place protection. So if somebody tries to attack you, in a sense, game the system to impede your production or your export, that you have some protection under Chinese law. Talk about that scenario a little bit more of, somebody who's an infringer, is actually getting ahead of you, registering your trademark, and then potentially preventing you from exporting the goods that you're manufacturing in China. Has that actual scenario played fully out, or has it only been a concern? And if it has played fully out, what does that look like?
It has played fully out a couple of times. It actually impacted a lot of pretty big brands. So how was it like is, we kind of, it goes back to one of the very core differences between the Chinese system and the Western system. In the Western world, in US, European world, when you start using a mark, you have rights. You don't need to register that. Well, register is always good, but when you use it, you have rights. That's why when a wine seller, for example, or a wine company, they produce the wine in Italy in a village for 100 years, people know about that and they have rights. But when you cross over the Pacific, you go to China, you go to Southeast Asian country, for example, there's no right. The rights are not recorded just because you use it. It's afforded when you start registering the rights. And why the infringer is so particularly more severe in Asia is because even if you've been manufacturing in China for like 20 years, 30 years, everybody, the villages all doing your products. But the problem is, if you're a manufacturer, you're a distributor, or even your retailer, you're a disgruntled employee, they beat you and the race, they go register the mark first in China. They are deemed the brand owner under the Chinese system. That's how they can turn the table around and start a lot of chain reaction. So that's a long way to explain how does it play out. If that is the circumstances, they are the right holder. They are the brand owner in China. We are now the infringer of our own brand. So they can turn it around, report us to the policeman, even record that and seize the products from coming out of China. So the question will be, how do we address that? There are laws in China. In fact, the Supreme Court, Chinese Supreme Court got a really good decision, made it really clear. But the bottom line is, do I want my clients to even get there? No, because especially for Amazon sellers, we're not talking about top brands or something like that. We're talking about protecting our bottom line. If that is the case, by all means, get certificate. Get something ready. So when the police come, knock on your factory, you got something you can produce.
Right. Yeah. No, that's great to hear about these sorts of scenarios, because one of the things that is hard as an Amazon seller is, across Amazon and competition and tax and regulatory, there's all these kind of risks and scary things that you hear about as kind of rumors. And to know that this is, these are real issues that are getting hit by real companies, in fact, very big companies, is really important for sellers to know. So, the kind of next obvious question is, okay, now if I'm going to be very diligent about this and make sure to protect myself by being more proactive and kind of getting more ahead of the curve in terms of registering trademarks, how much does it cost roughly, you just ballpark, to get trademark protection in China? And then, kind of maybe more broadly, in North America and Europe, kind of beyond the U.S. So what's the cost of being proactive about dealing with this if I really do already kind of own my brand?
Okay, so we're not talking about like huge amount of number. It's actually pretty comparable in the U.S. That's just assuming, and just back up a little bit. When you register a trademark, from filing all the way to getting a registration, in between, there will be amendments, there will be refusals, all that kind of stuff. But that just assume the stars and this moon and the sun are all lined up, everything is perfect. So from start to finish, for US, you're talking about probably $2,000, around that part. For EU, for European protection, it's about $2,500 to $3,000. For China, it's comparable. It's about $2,500 to $3,000 from start to finish.
Yeah, yeah, and those numbers roughly match with what I experienced. I think on the U.S. side, I was able to do it a bit cheaper because the system is actually pretty logical, and you can do self-filing. And actually, when I originally filed trademarks in the U.S., I did it myself. But then later on, I had to kind of improve our protection, basically, and we might talk about this later. Go from a word mark, or from a logo mark to a word mark. And then I engaged a lawyer, and then it was, kind of in the cost range that you were talking about there. Yeah, so we're really okay. So let's put this in perspective. So we're talking about something that is getting close to $10,000, maybe, to get coverage of the kind of markets that Amazon sells into, plus China, as kind of a source country. So, and an average Amazon seller, might be making 5 or 10% kind of net margin after all costs. So, it's something where, if you want to spend like a whole year's profit on it, you might want to think about something like this as early as 100,000 in revenue. But I think most people can't afford to do that, right? Because their profits are going into all kinds of things like taxes and building up their inventory. So realistically, you're probably once you're kind of into the 7-figure seller range, into the $1 million and up, this is something that that should be one of these thresholds where you think about this and get more proactive about this. Great. Okay. Okay. So we talked about money. Let's talk about time. So once I make the decision to kind of get proactive and register a trademark in China, what kind of timeframes are we talking about for that process to resolve itself, and to me either to get that trademark or get a rejection or whatever, for the process to play out?
The process, it's about is roughly right now, it's about 10 to 12 months. Mm-hmm. From start to finish to get a mark in China. And sometimes, like, for example, recently we are seeing a 3 months ahead of schedule. It's because China just announced it's going to revamp the whole government structure, and IP is part of the process. So right now we do see that things are moving a lot faster, approximately 3 months ahead of schedule. And sometimes the companies will come to me and say, Amy, I just secured a deal in China. I need some kind of government proof. Sometimes the Amazon sellers don't know like what is the exact term, but the kind of government proof they are looking for is something that bear the chop. We call that the chop or the seal. In the Western world, we sign. Signatures is everything. In the Chinese world, we have it's chop. It's just a weird translation, but anyway, people call that chop. So
Yeah.
once you file, and then it's about 3 months, sometimes as short as 1 month or 2 months, you will get something called official proof with the chop. So that's about the timeline.
Okay, so this is fascinating to me. Okay, so I have 1,000 times been asked by a seller to sign with my chop, and every time I've been asked for that, I've just stuck my Western signature there. Explain this to me. So I'm actually really going through this process with you, Amy. So now once our trademark protection is complete, I will have a chop.
Well, you will have a chop if you just go on the street, you will have it. But the chop we're talking about is the official chop from the Chinese government.
Oh, okay. So I still need to make my chop. So this might be a separate conversation. I was going to just doodle something and call it a chop, but I don't know. I think that might not fly.
It's a big deal in China. All the dynasty changes is going back to the ancient history. They're all fighting for the official Chinese chop. So it affects a lot because a lot of time in here, for example, our mark is registered. And if you say, okay, Amy, I need a registration from the US, you go to the USPTO website, you download it, that's it. China is a different process. You will be like, okay, Amy, I need a chop. Somebody, like that you just said, one of the biggest retailer or distributor manufacturer, we are going to sign a deal in China. So they want me to provide them proof that I own this mark. How do I do that? The easiest way is you need some document with the Chinese government chop. So that's a filing receipt. That's the stuff that I'm talking about here. Yeah, so it's different.
Yeah. Okay, great. Okay, so now we talked a little bit about this, but I just want to make sure I'm clear. So, with these issues we were talking about with China, and some of the risks if you have no trademark protection in China, the risks of, people actually impersonating you and causing trouble for your business in China. If I get a U.S. trademark or even a global trademark, which we still need to talk about that, do either of those things provide any protection in China?
It is not a "it depends" answer. It's a very clear answer. No.
Ah, interesting. Okay, great.
You don't have protection, even though, because I have a lot of companies sometimes come to me and sometimes want to argue with me. I speak a lot, so a lot of people stand up in the audience and say, "How can this be possible?" The answer is I can spend an hour, and I have a lot of classes educating a lawyer. This is a textbook I help the Chinese government. This is the first ever Chinese textbook for trademark. But unless you're talking about top 10 category, unless you have $20,000 at least to spend and prove your mark as well-known trademark, the answer is no. Do not rely on your European rights, your US right. It does not matter. It does not matter in the Chinese system. What it matters is spend the $2,000, get it chopped by the Chinese government. That is your proof when you do business in China.
Oh, great. No, that's great advice. And advice coming from one of the people who literally wrote the book. I like that.
Yes.
Cool. Well, okay. So kind of getting academic about it. A lot of Amazon sellers have done a bit of research, or in other business efforts they've done, that they've dealt with the U.S. trademark system before. So one kind of really interesting angle is if you were to summarize, what are the major differences between the U.S. trademark system and the Chinese trademark system? To somebody who might understand a bit about the U.S. trademark system, what are those kind of key differences? You talked about a few of them, but how would you summarize that?
I would say the first major difference is use. In the Western world, you use it, you have rights. In the Chinese world, even if you employ 1,000 people, you've been using it in manufacturing for 20 years, unless you register or unless you're willing to spend $20,000 employing a lawyer or something like that, you don't have rights. So that's the very first bottom line, very, very core difference. The second biggest key difference that I see a lot of brand owner making mistakes, a lot of company making mistakes, is what's called the subclass system. And let me explain a little bit. In the Western world, in US, in Europe, there's it just, there's no what's called subclass system, because you examine stuff based on the market reality. That just says shoes and socks. Shoes and socks will be related in the Western world. But when you cross over the Pacific Ocean, you go to Asia. Asia is very common when it comes to trademark. They talk about subclass practice. What that means is that for goods fall under different category, they are different. So that's why there's so many problems in China, because people think with the US mindset, if I register for shoes, socks is covered. No. The bottom line is no, because it's different subclasses. That's why a lot of people say, actually, they think they registered the mark in the US, but in fact, they expose their mark to infringers because of the holes due to the subclass system.
Oh, yeah, the subclass system is really interesting to me. So I'm going to say some things about the U.S. system, but you correct anything that I say wrong. I mean, basically, my view of the U.S. system is, you register a trademark, and then it's allowed to be a little fuzzy and subjective about, kind of what types of products would be infringing if somebody else came along with a similar trademark. There isn't an assumption that trademarks cover everything, and yet, so basically, when we're doing maybe a trademark search, like we're trying to do like a product name or something like that, we'll look for anybody using the same word or even a similar word. And then we'll look at kind of what type of product it is. And if it's a same or similar product, we'll steer clear of that, because we feel like, okay, they've got a very strong case that they own the trademark in that area. But if it's a totally different kind of product, like one thing's a food product and one thing's an electronics product, then under the US system, there might not be a conflict between those trademarks. Sure. And what's weird about that is it's very fuzzy, subjective. Ultimately, if there's really kind of a conflict about that, it might only get resolved in court. So let me know if that characterization is correct. And then what I'm hearing about the Chinese system is that it's a bit more kind of just black and white, just based on paperwork. I claim a trademark in one of many classes. By the way, how many classes are there under the Chinese system?
China follows the international system. So on the surface, there are 45 international systems. That's on the surface is all the same. But what we talk about right now, the subclass system, is that each class, like class 1, class 25, they further categorize that into, it can be 20, it can be 100 different subclasses.
Within each of those 40 classes?
That's correct.
Oh, so we're talking about hundreds of, maybe even, does it cross 1,000? Is it more than 1,000 classes?
1,000. It just, I have a book right there. It's pretty thick.
Right. Yeah. Great. So basically, with the Chinese system, I'm allowed to claim my trademark in many subclasses. But I've got to go do it. There's no fuzziness about it. If I don't claim it, I simply don't have protection for that subclass. If I do claim it and I get it, I own that trademark for that subclass. Is that kind of like fuzzy versus black and white characterization kind of correct here as we're comparing the U.S. and Chinese systems?
It is correct in principle, because some of the big cases for pretty big names, like everybody knows about a name if I say it, we are trying to break away from the class, sometimes from the subclasses, subgroups, sometimes the class protection. For example, hotel brand. Hotel brand is class 43. If an infringer got the same hotel brand, but used that for high-end furniture, like let's just say Ritz-Carlton, high-end furniture Ritz-Carlton in China, or high-end furniture for Ritz-Carlton, because Ritz-Carlton is class 43, is for hotel services. Infringer will take it, and let's just say furniture, alcohol, real estate services. You need to break away from the subclasses. That's where litigation is about. And China does have the law to allow you to break it. It's very expensive. But when it comes to smaller scale Amazon sellers that we just want to source from China, we just want our bottom line protected. The most important part in this category is, yes, it is more cut and dry in China. In the Western world, it is more fuzzy because people examine that based on what's the reality. In the store, people are going to get confused. But in China, I should get that book is right next to me. But in China, when you fall under different category, different subclasses, they don't care in reality are they related. They just care on the book that is different. So that's why one of the sports brand fighting right now, big sports brand, but they have an infringer for gym bag. Mm. So in Western world, you would think, oh, sports brand, gym bag, they should be connected. But in China, different subclasses, end of the story.
Interesting. Really interesting.
For Amazon sellers, we don't want to have to even get involved in this kind of fight. So all it matters is that we just know there are different subcategories. The money is the same. Go ahead and get it covered.
Yeah. No, and it's interesting, the advantages and disadvantages of a fuzzy versus specific system. In a way, the fuzzy system does kind of produce pretty good outcomes because people are allowed to use some judgment. But it also is a system that really benefits large and kind of wealthy, companies with a lot of money, because you do have to sometimes threaten to take things to court or actually take things to court to resolve that fuzziness. Whereas the more black and white system is as long as you are proactive, you actually get really good protection even as a small company.
I'm so glad you say that, because even though I'm part of the team going to China and criticize this system every single year, we do see a lot of improvement, and we do see there's a rationale behind that, because a lot of people will say, well, it's just crazy, I'm not going to get protected. But the reality right now is the trademark filing volume in China right now, just last year, it's 11 times the volume than the US. Yeah. So it's hard for them to examine the fuzziness depending on like subjective discretion and all that kind of stuff. So they just make it black and white. That's it. And the other big thing is US has the precedents. They are bound by precedents. So we need to search case law, that kind of stuff. In China, no. You can point out to them black and white, hey, your examiner, the examiner sitting next to you, if you rule it this way, you rule it the other way. Well, the discrepancy, I was like, well, go figure.
Right. Yeah. That's a good point. Great. So now, we have the trademarks and other people have their trademarks. Let's talk a little bit about kind of how trademarks end up getting used. One of the, really key worries for people who are producing products is a lot of times products need to have certain logos or certain information that are just part of what the product is, that is kind of about compatibility with other things or compliance with other things. And very often the way this gets expressed is logos. Like in the technology world, for example, there's tons and tons of these technology logos that kind of represent compatibility with something. And very often those logos, the trademarks for those logos are owned by an industry organization. So now we're talking about kind of the other side of the coin of kind of like I, as a Amazon seller, want to be able to put somebody else's trademark on my package, but I'm worried about potentially what are the consequences of that. And very often those consequences play out at import and export because most governments, that's kind of where they have proactive enforcement of trademarks. Like, for example, in the U.S., we have Customs and Border Patrol. They handle immigration, and they also handle inspecting goods at import. There's situations where they'll engage when they, kind of see a product coming in with a logo, and they'll actually proactively do things to make sure that there's no trademark violations happening. So how does this work, and how is this area different between like China, maybe especially as an export source, and the U.S. As an import source or export source?
So in theory, because one of the presentation we focus on this area, there are some statistics coming up from China. So in China and Hong Kong, actually, we look at these together. In theory, it's pretty much the same in the U.S., but in practice, because of the volume, like what are the chances of your products getting pulled out and is examined? pretty very, very low. There was I don't want to misquote, but it suggested it was very, very low. But when things become really relevant especially for business, in terms of import export in China, import export in Hong Kong, there's one scenario, because China and Hong Kong is one of the few countries in the world that allow trademark owners to record their trademark. So what happens, it's kind of like the tax day, because we just went through the tax day. Normally, when the chances of you being audited, probably not very high. But if somebody actively report you, that means somebody actively report a trademark and ask the officials to monitor these, the chances of your products being pulled from all the record will be a lot higher. And
Right.
China does have that system. So what happens is that let's just talk about the infringer, the counterfeiter example. Somebody got your mark, the one that we talked about earlier. We do see, this is really rare, but it does happen. Some of them got so aggressive, they will actually record the brand with the custom officials in China, and they will find the port that you ship out the most, and they put it there. So that greatly increased the legitimate brand products being pulled, and that create problems.
Right. Yeah. Yeah, and it's tricky because on the U.S. side, the crazy U.S. government actually publishes where all of your import and exports are occurring, and from what entity and what entity on your side, and you actually have to request that be held confidential and renew that request every few years, or else it becomes extremely easy for somebody, China side, to know exactly where your import export is occurring, to target you this way.
Right.
Yeah.
So that's a very sensitive area, and is one of the areas that was most difficult to deal with, because the turnaround is usually very, very short, like 3 days, 4 days, and it usually happens during Christmas time. So you just affect a lot of shipment back in the U.S.
Right. Yeah. Okay. So if we want to talk about kind of, let's say we do have that $1 million Amazon seller. What are those best practices of being proactive and really kind of covering your risks in this category in the smartest way? Once you kind of cross that sort of threshold, and you need, it's in your interest to get proactive in this area. What are the things that seller or that person should do?
Yeah, I think about because people always ask me, what is the best practice? What is the most important thing? I think the thing is, just be aware that people don't know what they don't know, and make sure you hire somebody who has been hands-on, like in this kind of system, day in and day out. I was just listening, like one of my favorite singer, Bruno Mars. I was just listening to him when I was getting on the program. I just say, like a typical example, because some of these stuff that I talk about, even in the book, people would think that's kind of crazy. But in the US, you register Bruno Mars, English, that's it, protected, done. In China, you go register Bruno Mars. Sometimes it's very hard for people to pronounce Bruno Mars. So the Chinese market will create 5-7 different names for Bruno Mars. That's translation, transliteration concept. Then the Chinese market will have a nickname. Then you need to file a mark for English, Chinese to get it combined. So you're talking at least 4 different forms just to make sure your brand is protected. So best practices, one thing is US, Europe, you can do it side by side, legal and business. In China, Asia, Indonesia, Philippines, legal actually move forward because the system is different. So the general timeline is 3 to 4 months before your brand is going to be announced, before you are going to hit the mall and just do a lot of deal. Make sure you're protected by registration. So that's the first one, timeline. The second one, just be aware of the system. Subclass system is the key that's going to get a lot of Western brand. Just be mindful of that.
Oh, great. Well, thanks so much for being willing to have this conversation, Amy. And this is actually going to be provided to the attendees of the Seller Velocity Conference, which is happening in New York City in April 26th here, 2018. And we're so thankful to you for having that be shared as some great advice to everyone attending Seller Velocity. So for them and everyone else who will see see this, if they are one of those sellers who it's time now to get kind of more proactive in this area, how can they best reach out and contact you?
We have a blog. it's
Yeah.
So it's lastweekinchina.com. So in there, a lot of breaking cases and stuff, which is provide that for free. From there, you can reach out to me. So.
Oh, great. Okay, good. So lastweekinchina.com. And we'll also put a link, at the bottom of this video to that and any other resources that actually, Amy, you go ahead and put whatever links you want at the bottom of the video.
Google China Trademark Amy Hsiao, and my name pop up. So
yes, because expert. So again, thank you so much, Amy, and it was great talking with you about these really important topics.
Thanks. Bye.
Bye.